The Deputy Leader.
And if I might, just by reference to those eloquent remarks just now, I can say from first-hand experience there's nothing like playing against the Sacred Heart football team. Yeah, they know how to play the game for sure. Mr. Speaker, I rise to address the bill and indicate on the lead speaker. I also indicate the opposition's support for the bill. The Deputy Premier's the government speech at the end of the last sitting week, and I'd just address the bill briefly and make some remarks about the context in which we are navigating this step. So first of all, we're seeing the adaptation of the Act to apply what the government has said very clearly at the outset is an integrity measure, an integrity measure that applied automatically for so long as a former judicial officer was in the role of Commissioner, and that integrity measure no longer carries across because for the first time a non-judicial officer, someone other than a retired judge, has been appointed to the role of Commissioner. That occurred on the 12th of December last year, and I take this opportunity just to indicate my appreciation for the service of the Commissioner, and to indicate the appointment of the first non-judicial Commissioner is both a first for South Australia in the relatively short lifespan of the ICAC, and it's also one that I'm particularly pleased to see and to endorse and to offer every encouragement. In my short time in the role of attorney, I had the occasion to appoint Emma Townsend as Director of the Office of Public Integrity, and so I had the opportunity to be closely considering who would take on that role at a time where the triumvirate, if I call it that, had just been newly reformed, and the person who was going to take on the role of Director of the OPI was very much taking a step that was a first. The OPI had existed, but was wrapped up in the ICAC until then, without unpacking all the whys and wherefores and the merits and so on. We had a newly separate OPI, and the Director of the OPI was all of a sudden cast in a significant and substantial role of senior responsibility, and Emma Townsend undertook that role with distinction and for I think then around about 3 years, was the first director in that new structure, and as including among other things as a member of the Crime and Public Integrity Policy Committee, had occasion to cross paths with the director and to to understand the role that she's been navigating, and I'm sure she will undertake the office of Commissioner now with the same dedication and I expect distinction. And so for the first time here we have in South Australia a Commissioner who's not been a judge appointed to this very significant and senior integrity role, and the government has formed the view that in order to maintain that point of independence and integrity as an integrity measure, the application of an equivalence to a judicial pension, albeit by way of an adapted scheme, it's the subject of Clause 4, will ensure that that high level of independence and integrity is maintained. And I just stay with the point because what's clear in all of that, and might be noted for public record, is that, and I think distinction might be drawn with what occurred for similarly meritorious reasons a few years ago when the DPP was appointed, and coming off the bench to that appointment, arrangements were made in relation to the application of judicial pension at that time. In this case, what the government's made clear is that this is a point that government has considered as an integrity measure, and well and truly after the appointment, as I understand it. And so it's not some sort of enterprise bargaining arrangement, and it might be that it's a good thing to place the now former director in that kind of clear air. It's not something that's specifically at the feet of the former director in coming to the role of Commissioner, but rather the government, as the government said in its speech, coming to this considered view on its own in terms of the application of this integrity measure to a role of independence. And that's understood and appreciated. There's no doubt that at all times, those of us in roles that are looked at closely and daily in terms of their capacity to be free from influence, free from corruption in all its forms, integrity measures of this kind are well to be within the consideration of government, and so this occasion to apply that judicial pension structure to this role, albeit in an adapted form, is well and truly understood in terms of the government's independent consideration of that matter, regardless of the particular appointment and the particular occupant of the office. And I think it was important just to make that point clear. The Minister, in further addressing the government's view of the matter, has highlighted that we've seen a mixture now of judicial and non-judicial participants in anti-corruption roles around the country. It's neither ipso facto that this sort of pension arrangement applies, nor is there complete absence of precedent. So it's important to navigate this territory. But I think in the purposes of this bill, important to highlight, and I say so with the endorsement of the opposition, that the consideration of the application of an integrity measure of this kind is one that has important work to do. The government's already addressed the way in which the structure will apply in terms of minimum period of service, the avoidance of having been removed, or on the other hand, circumstances where the Commissioner might later be appointed a judge, incremental arrangements for time served, and so on. That's all clear on the face of the structure, and I just indicate that while there's always an imperfect analogy when one's comparing one role to another. Of course, judges are appointed, and necessarily until a statutory retirement age of 70, and the Commissioner in this case is appointed for a term, and there is the possibility for extension, and there is therefore a structure about how much time is served, and a sort of a rational treatment of the way in which the pension accrues. One can always point to some less than complete freedom, therefore, from the connection between time served, reappointment, and so on, and that complete independence. It's a balance that's been struck, and a structure that's been reached that both recognises the actual amount of time served, and the fact that that is done in accordance with a contract, and that's noted. A contract, a term of appointment at least. The only other broad point that I'd just address about the government's consideration of subsequent appointment is one that I'd perhaps thought to share in terms of advancement, for want of a better word, from not only this role to a judicial appointment, but from one judicial appointment to another, as has happened in very many cases now over recent decades. There is, I think, a respectable view that wherever it's practical to do so, these roles of independence ought not be connected with the possibility of, as we're seeing, advancement within them. So we've seen, and I don't quarrel with it for a moment, but where there might be a judge first appointed to the District Court, later appointed to the Supreme Court, and these days later appointed to the Court of Appeal, and we haven't yet had a High Court judge. We have had plenty of Supreme Court judges who've gone over to the Federal Court. We've got to do all we can, and in this case reference is made to the Commissioner possibly being appointed as a judge, to ensuring that appointments of this nature are made with the utmost independence, and that we don't, as it were, establish a sort of a structure in which we're seeing the search for advancement within these roles as being somehow on display from one to the other. I don't think it is, and I think to the extent that public barracking goes on and parochialism goes on in this space broadly, I think South Australians are rightly highly impatient for the appointment of a South Australian High Court judge, and it's a rare thing for a High Court judge to come from a completely non-judicial starting point to that court. So, couch all those remarks in some context. The point about this whole bill is what the government's described as an important integrity measure by the application of a pension to an independent role highly associated with integrity, and in that sense, the necessity for that role to be whole unto itself is important to emphasise. Government's further highlighted that, and I've sort of mentioned the DPP earlier, it's also not without precedent in other roles in terms of the arrangements in place for the Solicitor General. To conclude where I started, the opposition supports the bill, and in particular, I'd draw attention to the fact that this is the government's consideration about an integrity measure that is about reinforcing what it takes to be independent in this particular role, and it's not something that has arisen in the course of the circumstances